And we are joined now by the chairman of the One South Africa movement, Dr. Michael Louis. He joins us now via Zoom. Mr. Louis, a very good evening to you. And thank you so much for speaking to us. Listening to Terry Tselane there speaking about what the possible scenarios are if there is a delay in the elections. Is that something that you're entertaining? Is this how strongly you feel about this court challenge to the Amendment Act?
Yes, well, good evening. And I think the one thing is that we live in a constitutional democracy, and this is a constitutional issue and not a political issue. We've walked this road for 2 years. We've been at every single standing committee meeting. We've actually personally did presentations to the IEC more than a year ago. We signed a petition to the president. So as OSA, we've really done our part. And the sad thing about it is that the papers before the Apex Court now is exactly the same papers that we lodged in our first submission to the Standing Committee 2 years ago. So nothing has changed and our voices haven't been heard. And this is just so sad because whilst everybody is concerned about the postponement of the elections, it goes about a human right. It goes about the power to vote. It goes about everybody having their say, and that their say is equalized and taken seriously. So we're very serious about the application and we believe it's the right thing to do.
And as I recall, there were various delays in finalizing this bill before it was signed into law by the president. As you say, some of these issues were repeated over and over again, but I'm just wondering what steps were taken to bring to the president's attention that the very things that we objected to during this process are still a problem before he actually signed it.
Well, I mean, that's why I really blame the state attorneys and a lot of the legal advisors to all the departments. I think Parliament was in a very difficult position because what happened is that Parliament has got their own state law advisors. The Ministry of Home Affairs has got their own state law advisors, and the president has got his own law advisors, and we know that they were all consulted, and we saw the submissions that were responded to by all these law advisors to Parliament. And every single one of them has conceded and said that this act currently as it stands is constitutional. Now, you know, those of us that are legal people are standing that we know that, you know, these things are all debatable. But the problem that we've got is I can tell you now that this bill is a flawed bill. It's unconstitutional. It needs to be challenged because what will happen if we go through the election in 2024 and some political party doesn't get the result that they want, I can promise you that post the elections, this bill will be challenged if OSA doesn't challenge the bill now.
And mainly it's the whole issue of the thresholds of votes for independent candidates and the formula on the allocation of seats and their reallocation in the event of vacated seats. Am I correct?
No, so One South Africa movement, that is the submission by the Independent Candidates Association. OSA is going only on barriers to entry and the wasted votes. Now, I could explain that to you that in the past, because it all goes about showing that you have got support. And so in the past, a political party that wanted to register had to receive 1,000 signatures to comply with, to say that they can qualify to stand.
So that's the threshold that I was talking about.
Sorry, is that the threshold? So,
yes.
No, sorry, I thought the thresholds because the independent candidates need to get 93,000 votes in the region to also as a threshold to qualify.
Okay.
But the 1,000, so it was always 1,000 signatures in the past for an independent candidate now to register. But now this new Electoral Amendment Act says that an independent candidate, for example, in Gauteng, needs to get 13,800 signatures to qualify to stand. Now, firstly, we can't understand where does this figure of 15% of a previous quota come from? Where is its basis? How did it come? How did they get to this? And it sounds like a number of 13,800, but The facts about it is that if an independent candidate wants to stand and receive 18,000 signatures, and it takes 5 minutes to get one signature, it will take that independent candidate to employ 6 people for 6 months just to qualify on signatures. And we do not believe that that franchises an independent candidate to stand and is fair and reasonable.
Mm-hmm. And what are your feelings about the provision for objections to independent candidates? Do you feel that that's somehow in itself also biased against them?
Well, look, I mean, the big thing is about the Act, and that's what we've always saying. Definitely the way the Act is written is that they definitely don't give the same rights to independent candidates as to political parties. There's a disconnect. The weighting of the value of a vote for an independent candidate to a political party is not the same, and that's why it contravenes Section 9 of the Constitution of the Equality Clause, that everybody will be equal in front of the law and receive equal protection. And funny enough, in the 2 years that I've been sitting in all these meetings, there's definitely a bias against independent candidates, and it's something that I really believe is something that needs to be dealt with.
Should the Apex Court find that the amendment bill itself prejudiced against independent candidates, let's talk timelines. What do you foresee how long it will take, it should take, to resolve all of these issues, and will it get us to a time frame that is within the calendar that the Independent Electoral Commission has said it will allow them to carry out free and fair elections?
Yeah, so I think that's why One South Africa Movement has done our application that we lodged on Friday as an urgent application. And also when it comes to remedy, because it's one thing to go and say that the Act is unconstitutional, but what is the remedy? And we believe that our remedies are so clean-cut that it easily makes the Apex Court to give a judgment to be able to make Parliament to remedy it in a very quick pace. We're very well aware that the Apex Court doesn't want to get involved in the legislative powers, and we respect the separation of powers. And that's why we're also asking the Constitutional Court just give a directive, suspend the current Act, the invalidity of the Act at the moment, but give some directives to Parliament to remedy the Act as soon as possible.
All right. Thank you so much for your time, Michael Louis from the One South Africa Movement.